when a bill is reserved by a governor for consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. Two options. Third option, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the proviso to the last preceding article. And when a bill is so returned, the house or houses shall reconsider it accordingly. Please mark this, my lord, within a period of 6 months. This continues. Whenever Constitution intended to provide for a timeline, the Constitution has provided for. This continues even in the present Article 201. And therefore, it is not permissible to lay down any timeline in other articles. I'll come to that. That's a separate point, my lord. Now, my lord, the debate, this debate, my lord, both of us would be relying upon. The other side would also, in fact, there cannot be any other side when it is a presidential reference. But, my lord, the other side point of view, my lord, they would also other point of view, my lord, they would also rely upon to say that the discretion was taken away. My lord, apropos, my lord, Justice Narasimha's question, whether subsequent debates throw any light on that discretion or not. Because Dr. Ambedkar says that this is the debate. Page 146 is that debate which my lords were referring to. But, my lord, please bear in mind that in 163, the discretion remained that aid and advice except subject to, my lord, by or under the Constitution. And I may tell your lordships, subsequently, there are no articles which specifically uses the word discretion. Subsequent to Article 163, there are no articles which confers discretion. But after reading this, my lord, debate, my submission for your lordship's consideration is going to be that if the article itself gives him options to choose from, use or not use of the word discretion does not matter, because he is that you choose from either of these four.
Then the discretion has to be exercised among the options given in that article.
Lord, I'll come to that.
If the article provides for 4 options,
yes,
then the discretion would be restricted to only one of those 4 options.
Correct. I bow down. It cannot be beyond that. Governor is bound by one of those 4 options. But which option to choose from?
It is discretion.
It is his discretion. Lord, for example, for the purpose of granting assent, the Council of Ministers would always say that grant assent, it is our bill. So there is no question of, my lord, he is using discretion.
That will be relatable only to that part of the question where it is sent back to the assembly for reconsideration and it is coming back to him. At that second stage, will he be entitled to send it back to the president for his approval?
There he would have the discretion.
This is where you are talking about.
That is there, he would have the discretion. He cannot withhold it.
That's your argument.
But, yes, that's my argument. My lord, but the problem has arisen because of State of Punjab judgment. No, not the State of Punjab judgment. I'll come to that, my lord.
But the issue relating to timelines is not relatable to the options.
No. That's a separate point. That's a separate. Your lordships are right. Timeline has nothing to do with the option or discretion, etc. Since I was there, since I was showing the provision where the Constitution itself prescribed time limit, since I was reading the provision which itself provided for time limit, I just as a reference said that whenever the makers wanted, they have provided for the time limit. And if it is required, it can be done by a constitutional.
The timeline which you are referring to is for reconsideration by the legislature.
Legislative time.
That is not a timeline given for the governor.
Exactly. That's my case. That's my case. That now you are reading something which the Constitution has provided, not provided. But that's a separate, my lord, argument. Please allow me, my lord. But since your lordships have given a very right and apt example, the withhold, my lord, whether withhold is a temporary act of withholding Or as the Supreme Court through 5 judge and 7 judge benches have said, that withhold means the bill falls through. Because there are circumstances where, suppose, my lord, normally the legislature is not expected or is not supposed to pass egregious, my lord, something, my lord, very extraordinary bills which are beyond their competence. But suppose, my lord, how we read the Article 200. My lord, suppose a border state passes an legislation which deals with our external affairs, that will permit a particular country's people to enter or not to enter.
You
What?
can respond to these.
Give me a minute, my lord.
As per the way you want. You are only pointing out that rest of the, this discussion ultimately leads to the final bill at page 150. And probably thereafter this issue arises.
Your lordships are right. My lord, then he cannot assent. He cannot refer it to the president because it's not a repugnancy issue. He cannot return it to the house because once he returns it to the house and house repasses it, then he is bound, he cannot withhold it. Then he will have to withhold, my lord. And I have given the examples. It is to be used rarely, sparingly. But that's the way the situation is. That withhold means the bill falls through. That's how, my lord, the 5 judge bench and 7 judge benches have understood, my lord, the Article 200. And I have given examples.
But then, if he doesn't, if he doesn't exercise the option of resending the bill for reconsideration to the governor, still he can withhold it for a time immemorial.
It dies. It dies. It is to be used rarely, but the power is conferred. My lord, rather than, my lord, entering into this debate right now, can I, my lord, just give the background? Now, my lord, I am on interpretation of Article 200 and 201. Please come to page 150. Let me read it, my lord, the way we believe it requires to be read. 200, assent of the bills. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council, has been passed by both houses of the Legislative Assembly, it shall be presented to the governor. Now, this is the first condition. And the governor shall declare. This is his obligation, constitutional obligation. He has to make a declaration. What? 4 options. Either that he assents to the bill, or second option, he withholds assent, withhold assent therefrom. Third option, or that he reserves the bill for consideration of the president. I'll come to, my lord, Article 254, which says that this reference would be necessary only if the bill is repugnant to some central law, not otherwise. He cannot refer it for any other reason. That
Referring it to the president.
Yeah, then he can refer it. He has to refer it. That's the mandate. My lord, if there is a repugnancy with the central law, he will have to refer it. Now the 4th option, provided that the governor may. It doesn't say shall. Governor may. And something would turn when I, my lord, point out.
Mr. The one read. Let's read it again, the first part.
I'll read, my lord. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council have been passed by both houses of legislature of the state, it shall be presented to the governor,
Right.
and the governor shall declare either.
Yes. So declaration has to be in both cases, whether he assents or whether he withholds.
All 4 cases,
No.
all 3 cases.
Yes.
Yes.
That declaration has to be there.
100%.
It is not that he will not make a declaration and withhold it.
Yes, he will have to declare that I have withheld it.
Correct.
Bound, I bound out. That is the only way it can be read. Yes, he has to declare. One of the 3, he will declare either first option, he assents to the bill. Then no dispute will remain.
So according to you, if he declares that it is withheld, the bill is said to be failed.
Yes, it falls through. Supreme Court says, 5 judge and 7.
In other words, what you are saying is, when it is communicated to the assembly, that it is withheld, it cannot be placed back before the assembly for reconsideration.
Correct.
Yes.
What you're saying?
Yes.
Wording, the meaning of the word
Refusal
withholding
to
means,
grant assent.
There will be a declaration in public domain assigning the reasons that these are the reasons I am withholding.
Reasons, there is a separate issue. Declaration that I withhold. Because sometimes, my lord, reasons can be in national security for my lord, with profound respect. Lord, the powers are given by the constitution.
Say that, no,
Before I answer that, no, first of all of us derive our powers from the constitution.
yes, yes, of course.
We neither give nor take away. Nobody can, my lord. There are three organs. But it's not, my lord. Let me, my lord, complete. Then, my lord, I'll be able to answer your lordship's questions, my lord, more effectively. Right now, your lordship's first brush reaction is that if withhold is held to be power to reject the bill, it is there. That's my case. I'll have to make it good. Provided that the governor may, my lord, the fourth option.
Yes.
So kindly park that question. I'll answer that question. My lord, therefore, I am requesting your lordship, my lord, to park that question right now. That's not my case. That's not my case, my lord. That's the extreme case visualized in Tamil Nadu, and my lord, whether we like it or not, my lord, we are burdened with the Tamil Nadu facts. I'm arguing dehorsed Tamil Nadu facts. Correct, my lord? So he has three options. He will have to make a declaration that I assent. I withhold, which according to me, bill falls through. I'm not accepting that. I'm taking that argument head on. Yes. Third, if it is repugnant because of Article 254 with some central act,
It has to
we
go to
will
the
have
president.
to my lord, refer. But there can be an act with the rather bill, which is of such a nature that it may have some provisions which are repugnant. It may have some provisions which may violate somebody's fundamental rights, or it may have some provisions which, according to governor, is not desirable.
Yes.
My lord, may I request your lordship? My lord, I have understood, my lord, what is.
Yes, now we will not interrupt you. Yes.
No, I'm not saying. Yeah, it's not an interruption, my lord, your lordship. That dialogue, my lord, only permits us, my lord. Let me, my lord, say that the question of withhold, whether it is permanent or a temporary till he returns, is the question. I will show your lordships, my lord, some examples. No, Punjab judgment, without noting 5-judge and 7-judge judgments, it's a 3-judge judgment. My lord, Justice Chief Justice Chandrachud, Justice Pardiwala, and Justice Manoj Mishra, without referring to any of the binding 5-judge or 7-judge judgments, have recorded, my lord, the finding that withhold means you have to you read it with the proviso, which I will show and demonstrate, at least attempt to demonstrate that, yes, and I want to show that, and what earlier judgments have said on the question of withhold.
this is what
Thereafter,
you
my
are
lord,
saying.
the last part, withheld, my lord, with a while, my lord, immediately answering, if the way in which, my lord, the Punjab judgment, my lord, understood article, the last part would have been, he shall grant his assent. He shall not withhold. My lord, the power to refer still remains. But that's not, my lord, right now the question. My lord, I have read, my lord, Article 200. Now, Article 201. What happens, my lord, when bill is referred by the governor to the President of India? That is 201. When a bill is reserved by the governor for consideration of the President shall declare either that he assents to the bill or that he withholds assent therefore. Withhold means, my lord, bill falls through. I'll show, my lord, from the judgment. Provided that where the bill is not a money bill, the President may direct the governor to return the bill to the House, or as the case may be, the houses of legislature of the state, together with such a message as in mentioned in the first proviso to Article 200. And when a bill is so returned, the House or Houses shall reconsider it accordingly within a period of 6 months. Please mark, my lord, as a separate point, Constitution provides for a time limit. The date of receipt of such message, and if it is again passed by the House or the Houses with or without amendment, it shall be presented again to the President for reconsideration, it does not say here that thereafter president shall not withhold it. Meaning thereby the ultimate power of the president to withhold desires.
Correct.
And he is thereafter not under an obligation not to withhold, as my lord
As
provides,
the 200 or
200 my lord provides. Now please see, my lord, what is, my lord, how I, my lord, beg to interpret this, my lord. My lord, at page 152, I have given, my lord, I'm not reading, several provisions, my lord, where governor exercises executive powers,
Yes.
he exercises legislative powers, my lord. There are powers, my lord, which are quasi-legislative in nature. I may not, my lord. Please come to 154. And then immediately I'll switch over to the judgments, my lord, on this. On true construction of Article 200, the governor is entrusted with 4 options. My lord, I have narrated.
You are referring
Neither
to page
context, 154.
154.
154. Neither contextually nor textually, it is possible to conclude that the term withhold will have to be read as a temporary suspension of power of granting assent till first proviso works out. There is no concept of temporary withholding of any bill. If the framers of the Constitution would have intended to link the term withhold in the main part of Article 200 to read only in the context of the first proviso, 2 things would have been provided. A, the term withhold in the main part would have been qualified by the term subject to first proviso mentioned therein. In the main part, they would have said that you withhold subject to following the provision. And B, the first proviso would have mentioned that the bill so withheld shall be reconsidered by the House, which is not that. I am going on textual interpretation, my lord. In other words, the power of withholding in the main part of Article 200 is an independent and unqualified power. However, out of 3 possible powers contemplated in the main part, having not been resorted to by the governor, by giving an opportunity to the assembly under the first proviso, the governor cannot fall back again on the main part and withhold the bill passed once again, with or without suggestions of the governor. In other words, if the governor wants to withhold the bill, that is resultantly the bill falls through. Please mark these words. These are the words I have borrowed, which are used consistently by the larger benches. The bill falls through, he has to do it at the outset. If he chooses not to exercise that power at the outset, he is denuded of that power if he chooses to return the bill under the first proviso, because of the last part of the first proviso. The governor is expected and empowered to withhold the bill in the main part of Article 5 and 17, Judge. Also. No, my lord, all are 5. I stand corrected. My lord, there is a judgment of Samsher Singh, but that is on discretion, not on withholding. Samsher Singh is 7, Judge. It's
coming.
It's coming. Therefore, my lord, yes, my lord, withhold has, my lord, its own meaning. And I will show, my lord, why this has a meaning and why that meaning is required to be given in the main part. And what kind of rare contingencies which are contemplated, where you cannot assent. That's not, that's in a commercial parlance, yes. That we withhold this issue. Right now, we withhold the file, but that's not the way in which it is used. That's not the way in which it will become very clear. No, because it has come right from, this word has been taken from 1919 Act, 1935 Act, and now present Act. So it is not debated in Parliament. We will have to independently examine. Your Lordships will have to examine. We will assist your Lordships in that. But I'm just right now, my lord, please consider, without keeping in mind some egregious, my lord, facts where someone may withhold without any application of mind, or just out of political frustrations. I'm just trying, my lord, to say that the governor is not that way powerless. He has 3 options, subject to the 4th option being exercised, my lord, and all 4 options are independent of each other. Now, please see, the governor is expected, para 97 at page 155. The governor is expected and empowered to withhold the bill in the main part of the Article 200 when he finds that the entire bill is beyond the legislative competence of the legislature. Then he can't return it. If the entire bill covers atomic energy or defense or external affairs, it's repugnancy only. But if the entire kindly allow me, it would then it's not a question of repugnance. It's complete lack of legislative competence. It would be, my lord, ultra-vires. Then two, the entire bill violates some constitutional provision or some fundamental rights. Entire bill. If it is a part of it, he can say that I refer it to you. If you still continue it, I can't withhold it, then it would be set aside by the Supreme Court if challenged, or the High Court if challenged. Even though the bill is within legislative competence and does not violate any fundamental rights, it is so manifestly arbitrary that it cannot be assented to. This is where, my lord, his statesmanly discretion would come, and I have given the examples. Please, my lord, minutely observe, because this is how, based upon your lordship's opinion, the polity of the country would govern. My lord, I am not arguing that present government is in center is a political party, state as a B political party. My lord, it can be reverse also. There are, my lord, political parties in the state which is, my lord, same party at the center. So we are not, my lord, on conferring discretion on the governor to my lord, kill the bill. That's not, my lord, the idea. It's really the interpretation of the word withhold. Political parties will keep on changing, my lord, in the respective. So therefore, my lord, my attempt is as a neutral student of law. This is how I perceive the constitution interpretation to be. Even, my lord, 98. In case the governor feels that either only a part of a bill is beyond the legislative competence or a part of the bill which violates some constitutional provision or abridges fundamental rights, he may return the bill so as to allow the legislature to cure the defect. The first proviso in case of a bill where the defect found by the governor is curable. When the governor feels that some part is curable, if you make a legislation for, say, defense of India, then it's not a curable bill. And I would not, as a governor, do that. I'll return it because thereafter I can't even withhold it. So that is where the term withhold at the first instance comes. Then 99. If the above interpretation is not given, it will result in disastrous consequences. Normally, it is presumed that all legislatures, in their collective wisdom, will not pass a bill which is manifestly unjust or arbitrary in its entirety. The power of withholding of the bill in the main provision, therefore, shall have to be used sparingly and only in extraordinary situations, when the very constitutional existence of the governor, who represents the democratic will of the nation manifested by the President of India, would be frustrated. Now see, my lord, examples I have given. These are hypothetical examples. For example, if the legislature were to pass following bills, the governor would be abdicating his duty if he does not withhold the bills, as he can neither assent to the bill nor reserve the bill for presidential reference. 1. If the legislature were to remove the concept of reservation itself in the entire state. 2. If the legislature, while removing the reservation based upon the parameters of Article 15 and 16, provides for reservation only based on religion, that only Hindus will get reservation, or Muslims only will get reservation. 15, 16, we are not bound. Third, one state legislature passing a bill preventing residents of other states from entering in that state. Lord, this is a state subject. But the governor may feel, and this has happened, my lord, I'm a slight deviation. This has happened not by way of a legislation during COVID. I'll not name the states, my lord, and everyone was doing in their own right. There was, my lord, one state whose hospitals were flooded with patients. So they were sending the patients to the neighboring states. And the neighboring states was fearing that we will also now feel shortage. Your lordship, my lord, knows. So, my lord, barricades were created that one state people will not come in the other state. It was, my lord, a different fact situation. But suppose a bill is passed. I'm just giving, my lord, an example. The state legislature mandating use of only one particular language as a mandatory requirement for all residents of that state. Look, it is, my lord, a subject of the state list. It can do. The legislature excludes a particular class of people from exercising right to vote, either based on caste, sex, education, or any other ground. Earlier, my lord, only there was, my lord, a limited franchise. All citizens of India were not entitled to vote pre-constitution. A bill is passed by legislature giving complete immunity to the entire cabinet or all elected members from criminal prosecution. Well, then I cannot, as a governor, act on the aid and advice of the for the very nature of things, my lords. A bill prohibiting central agencies like income tax authority, etc., from exercising their statutory powers within the geographical limits of that state. A bill providing for provisions which undermine the authority of high constitutional functionaries like the President, the Prime Minister, the judges of the Honorable Supreme Court, etc. Now, last, a bill which deals with jurisdiction of the Honorable Supreme Court of India itself. Lord, before I examine this, please see the second proviso to Article 200. Second proviso, my lord, please come back to page 150. This is the classic example, my lords. My lord, I'm not saying, my lord, elected people are responsible people. They act through their collective wisdom. But there can be one circumstance out of 1,000 where such an aberration happen. Lord, please see the second proviso to Article 200, my lords. Provided further that, your lordship gets, my lord, the governor shall not assent to. My lord, first proviso said he may, my lord, return it to the house. Governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which the court is by the position of which that court is by this constitution designed to fill. My lord, suppose the act says something, and my lord, as per the true reading, there can be a local law with regard to the powers of the High Court that would be mandatorily subject to presidential assent. We are not concerned with that. I'm on a different point. Forget, my lord, High Court. Suppose the legislature passes some act. No, it cannot grant, my lord. I'll come, my lord, on that textual interpretation also. Yes, but I'm just giving an example that suppose legislature passes a bill which directly deals with the powers of the Supreme Court. If it is High Court, I'm not on, my lord, whether I show that, my lord, only to show the absurdity of the potential bill. The lordships are trying to find a solution, my lord, find some conclusion. I'm still on, my lord, the problem. And after your lordship sees the problem, my lord, possibly your lordship may be in a better position to find out the solution. Suppose, my lord, in case of a High Court, the governor is bound to send it. In other cases, he may not. That's the discretion, because the main part says he may assent, he may withhold, he may refer. But proviso say he shall refer. So I am using it against, my lord, the proposition. Please see, my lord, just to immediately answer your lordship's question, the main provision says the governor shall be houses the legislature of the state. It shall be presented to the governor, shall declare that either he assents or he does this or he does this. So there are three options. But here there is no option. Here he has to reserve it for the president. And therefore, my lord, my submission that in the main part, there are three options available, gets 45. Lord, be that as it may, my lord, I'll come to that.